Quando el quid prohibitor ex directo prohibitor et per obliquum। ये एक लैटिन मैक्सिम है विच मीन्स जो काम हमें डायरेक्टली मना है वो हमें इनडायरेक्टली भी मना ही है। हेलो गाइस, आई एम अनुकृति एंड आई होप आप सब ठीक होंगे। टुडे वी आर गोइंग टू डिस्कस द फ्रॉड ऑन कॉन्स्टिट्यूशन। यू मस्ट हैव हर्ड अबाउट इट, नहीं? We will be covering the Doctrine of Colourable Legislation, which is famously known as the fraud on the Constitution. We will discuss the meaning, origin, scope, applicability, related provisions, and the need for doctrines, along with its limitation and some important judgments relating to the same. So let's start with its meaning first. जब कोई लेजिस्लेचर एक ऐसी लेजिस्लेशन इनैक्ट करता है जिस पर उसकी कोई लेजिस्लेटिव कॉम्पिटेंस या पावर नहीं होती है, बट वो उसे इस तरह से डिस्गाइज करके प्रेजेंट करता है जैसे वो उसी की लेजिस्लेटिव कॉम्पिटेंस के अंदर हो, तब उस पर्टिकुलर लेजिस्लेशन को कलर्ड कंसिडर किया जाता है। एंड इन्हीं केसेस में डॉक्ट्रिन ऑफ कलरेबल लेजिस्लेशन यूज की जाती है टू टेक केयर ऑफ द लेजिस्लेटिव अकाउंटेबिलिटी। In Naga People's Movement of Human Rights versus Union of India, it was held that colorable legislation is enacting by the legislature of a legislation seeking to do indirectly what it cannot do directly. Doctrine of colorable legislation basically यही कहती है, what cannot be done directly should also not be done indirectly. जो काम हमें डायरेक्टली मना है वो हमें इनडायरेक्टली भी मना ही है। द डॉक्ट्रिन इज बेस्ड ऑन द लैटिन मैक्सिम जो हमने स्टार्टिंग में पढ़ा था, क्वांडो एल क्विड प्रोहिबिटर एक्स डायरेक्टो प्रोहिबिटर एथ पर ओब्लिकम, विच सेज द सेम। इस डॉक्ट्रिन का यूज मेनली कोर्ट्स करते हैं जब भी कोई लेजिस्लेचर ओवरस्टेप्स इट्स कंफर्ड पावर एंड लेजिस्लेट अपॉन समथिंग इनडायरेक्टली विच इट कैन नॉट डू इन अ डायरेक्ट मैनर। ऐसे केसेस में देखने में यही लगता है कि जिस सब्जेक्ट मैटर पर लॉ बनाया गया है इट इज फॉलिंग विद इन द पावर ऑफ द लेजिस्लेचर, बट इन रियलिटी उसका इफेक्ट या पर्पस कुछ और होता है, लाइक सम हिडन मोटिव, एंड दिस हिडन पर्पस क्लियरली फॉल्स बियॉन्ड द डोमेन एंड अथॉरिटी ऑफ द लेजिस्लेचर। That is why this doctrine is famously known as a fraud on constitution. This doctrine dates back to the colonial period, जब ब्रिटिश एम्पायर एक्सपेंड हो रहा था एंड दूसरी कंट्रीज को अपने अंडर ले रहा था। तब दे रियलाइज्ड द नीड टू डिफरेंशिएट बिटवीन द सब्जेक्ट्स ऑफ सेंट्रल एंड प्रोविंशियल यूनिट्स, एंड हेंस द डॉक्ट्रिन वाज इंट्रोड्यूस्ड। ओनली जुडिशरी हैज द पावर टू अप्लाई दिस डॉक्ट्रिन। बात करते हैं कि इस डॉक्ट्रिन से रिलेटेड प्रोविजंस क्या हैं एंड इस डॉक्ट्रिन की ज़रूरत कहाँ पड़ती है। So, under Article 246 of the Indian Constitution, the bifurcation of subject matter for the purpose of lawmaking is given. There is a threefold distribution of legislative powers between the union and state, which is made and aided by three lists given under Schedule 7 of the Constitution. अब ये तीन लिस्ट क्या हैं? इंडियन कॉन्स्टिट्यूशन में 7th शेड्यूल के अंडर तीन लिस्ट दी हुई हैं। फर्स्ट, यूनियन लिस्ट, जो ये बताती है कि किन पर्टिकुलर टॉपिक्स पर सेंट्रल गवर्नमेंट के पास रूल मेकिंग पावर है। सेकंड, स्टेट लिस्ट, जो उन टॉपिक के बारे में बताती है जो स्टेट गवर्नमेंट की रूल पावर के अंडर फॉल करते हैं। एंड थर्ड, कंकरेंट लिस्ट, that consist of those topics which will fall under the rule making power of both the union and state governments. And the same thing is specifically mentioned in Article 246 of the Constitution. तो जब इतना क्लियरली सब कुछ मेंशन्ड है फिर इशू कहाँ है? इशू तब क्रिएट होता है जब कोई भी एक लेजिस्लेचर अपनी बाउंड्रीज को क्रॉस करके लॉ बनाता है एंड उसे इस मैनर में प्रेजेंट करता है जैसे वो उसी के डोमेन एंड अथॉरिटी में हो। नाउ कमिंग टुवर्ड्स द स्कोप एंड एप्लीकेबिलिटी। So, what is the scope and applicability of this doctrine? The Constitution says कि अगर legislative powers को different bodies में distribute किया गया है तो उन bodies को अपने prescribed domain में ही act करना है। इस doctrine की meaning and scope को Supreme Court ने thoroughly explain किया है in the case of KC Gajapati Narayan Dev versus State of Odisha. The court stated in this case that If the constitution of a state distributes the legislative powers among different bodies which have to act within their respective spheres marked out by the constitution in specific legislative entries, or if there are limitations on the legislative authority in the shape of fundamental rights. The question arises as to whether the legislature in a particular case has or has not, in respect to subject matter of the statute or in the method of enacting it, transgressed the limit of its constitutional powers. Such transgressions may be patent, manifest, or direct, but it may also be disguised, covert, or indirect. And it is to this later class of the cases that the expression of colorable legislation has been applied in judicial pronouncements. The court further said that the idea conveyed by the expression is that although apparently a legislature in passing a statute purported to act within the limits of its powers, yet in substance and in reality it transgressed these powers. The transgressions being veiled by what appears on proper examination to be mere pretense or disguise. The essence of the expression is that only the substance of an enactment is material and not merely its form. In case the subject matter of the enactment is not within the legislative domain of the legislature, then the law made in the grab of that form cannot spare it from condemnation. Now, इस डॉक्ट्रिन की लिमिटेशंस क्या हैं? इस डॉक्ट्रिन की एप्लीकेबिलिटी पर कुछ सर्टेन रिस्ट्रिक्शंस भी हैं. So let's have a look on them. First, the doctrine is not applicable in cases where the power of the legislature is not limited by the constitutional provisions. Second, it does not extend to cases of subordinate legislation. Third, the intention of the legislature while passing an enactment is irrelevant to deciding its validity. And fourth, there shall always be a presumption of constitutional validity in favor of the enactment. Now, coming towards the landmark judgments. So, let's discuss some of the important case laws of relating to this doctrine. First, State of Bihar versus Kameshvarsi. This is the only landmark case under which the statute has been declared invalid on the ground of the colorable legislation. The validity of the Bihar Land Reforms Act 1950 was challenged. ये एक्ट इनडायरेक्टली पेटिशनर को उसकी प्रॉपर्टी से रिमूव कर रहा था इंस्टेड ऑफ डिटरमाइनिंग कॉम्पनसेशन फॉर विच इट वाज इंट्रोड्यूस्ड. The petitioner in this case challenged the validity of the Bihar Land Reform Act 1950 on the basis that the act was supposedly intended to lay down the principles of the compensation, but in fact it didn't lay out any such principles. This was alleged as an implicit attempt to deprive the petitioner of his rights to compensation. The court also upheld the unconstitutionality of the act. Next, K.T. Mupil Nair versus State of Kerala. इस केस में petitioner 25,000 acre forest land का ओनर था. Due to the Preservation of Private Forest Act 1949, the yearly income of the petitioner was only 3,100 rupees per year. फिर Travancore Cochin Land Tax Act 1955 existence में आया and Section 4 of the Act imposed yearly tax liability of rupees 2 per acre, and as a result, the petitioner had to give a tax of rupees 50,000 per year. Also, Section 7 exempted 78 types of land from the operation of this Act after notification. It was held that Section 4 and Section 7 of the said Act violates Article 14 and Article 19(1)(f) of the Indian Constitution. The Travancore Cochin Land Tax Act 1955 was held to be invalid on the ground that the act apparently purported to be a taxing act, but in reality it was not a taxing act but was confiscatory in nature. Next, coming to the other case, that is M.R. Balaji versus the State of Mysore. इस केस में मैसूर गवर्नमेंट का एक ऑर्डर was challenged under Article 15(4) for reserving seats for admission to the state medical and engineering colleges. The petitioner said that the classification made by the state was irrational and the reservation of 68% was a fraud on Article 15.4 of the Indian Constitution. The question was whether Article 15.4 gives constitutional power to the state to pass such reservation powers or not. The court held that the reservation is a fraud on the constitutional power conferred by the state by Article 15.4. So, the Constitution of India has made a rigid distribution of powers between the Parliament and state legislature, and each one of them is bound to act within its circumscribed sphere. लेजिस्लेचर की कॉम्पिटेंसी का क्वेश्चन अक्सर अराइज होता है when they seek to transgress the limits imposed by the Constitution, but these transgressions are not always direct or patent. To deal with indirect, covert or disguised violation scenarios, the Doctrine of Colourable Legislation come to the rescue. The doctrine acts as a fundamental tool to the judiciary to keep a check on the legislative powers granted to the union and state governments and decide the validity of the legislation in the question. If you want to read more about this doctrine or any other such interesting topics, you can visit our website for it. लिंक आपको डिस्क्रिप्शन में मिल जाएगी. Hence, the discussion comes to an end. Soon, I'll come up with the next topic. Till then, keep working hard towards your goal and keep watching Legal Bites. Follow Legal Bites for getting subject-wise knowledge on all the legal topics, mock practice series for the judiciary and much more. Please do like, share, subscribe to the channel and also comment it, as it keeps us spirited to go ahead along with the enhancement. Thank you.